be somebody who is willing to seek out things that make you uncomfortable. Get outside your comfort zone, run towards the resistance in some respect, because that's what's going to sharpen you. That's what's going to make you stronger as an attorney. If you are waiting until you feel like you're ready to do it, you're never going to have that level of comfort.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Nael Abuzaki.
We are back. This is a special episode, and it hits home and closer to home than you may think. We're interviewing the Broughton Injury Law. I got to know the firm through Sharif Gray when Sharif joined this firm, and have gotten to know the attorneys and heard a lot about not only the work that they do, but the reputation that they carry. So I'm going to have each and every one of y'all introduce yourself, and I'm going to start with Gray Broughton.
My name is Gray Broughton. First of all, thank you both for having me. Really appreciate the opportunity. Gray Broughton, I started this firm. Not sure how much you want me to talk
and
about
Gray,
now.
when did you start the firm?
Back in 2018, end of 2018. So good timing as a personal injury attorney right before the pandemic struck and no one drove around and no one went anywhere and no one got injured.
And Sharif, when did you join the firm?
A little over a year ago. So I think it was July of last year. So,
And that's when you couldn't hold jobs and finally landed here.
knock on, well, that's not real wood, but I like where I'm at. So yeah, I'm good at moving on when it doesn't work out. But no, I'm super happy here, and we've had a hell of a year. So it's been good.
And Zac, I'll have you introduce yourself.
Yeah. Again, thank you both as well for having me on. My name is Zac Grubaugh, another one of the trial attorneys at the Broughton Law Firm. I joined the firm in August of 2023.
So going back to Gray, let's backpedal to 2018. What was the impetus that led to the formation of this firm?
So it actually goes back a little bit further than even 2018. So I used to be an attorney at Williams Mullen. I'd been there for about 9 years. Prior to that, I was in the JAG Corps of the Army, stationed in Germany and Korea and Iraq. And one of my good friends who I served with in both Germany and Iraq, he'd gotten out of the Army, was living up in the DC area up in Maryland. And I got a call one day from his wife that unfortunately he had been in a severe, terrible car accident, and that their 7-year-old son was also in the car at the time. Fast forward a little bit, my friend suffered an injury and was out of work for a year. Their son, unfortunately, thankfully he survived, but he lost his leg above the knee, had a traumatic brain injury, and it was, at that time, my friend's wife, who's also with us in the JAG Corps at the time, she called us and asked for me to take on their case. And so I'd never handled a personal injury case before. I was doing white-collar criminal defense, a little bit of commercial litigation. And so the first case I ever handled, which is personal injury, was this humongous case that was not only big from a value proposition, but also struck home because it was people that I knew very well, people that I was there for the birth of this young man who was 7 years old at the time. And so it was very personal to me. And so fast forward a little bit, it ended up being something where I felt a calling to go into personal injury, eventually left Williams Mullen, joined Kaplan Vogler at the time, which funny enough is now part of Williams Mullen, and kind of transitioned there to eventually go off on my own and open Broughton Injury Law.
So it started with an injury to a family that hits home. I want to touch on that a bit before we transition. How were you able to control that emotion, given the fact that there was a lot of love? And often, you feel love, but you say you feel love when you want to distance yourself from the love that you have for the people. At that time, you just felt love, right, for them, and it was part of you. How were you able to kind of decipher the attorney, personal injury attorney, and that family friend, and be able to represent them?
Yeah, I mean, even now, the collision happened back in at least over 10 years ago. And even today, I still get chills thinking about it and almost kind of tear up thinking about it. But, I was fortunate at the time. Drew Galloway, Ed Williams Mullen, I partnered with him on the case. So he had handled a lot of personal injury cases. And so I wasn't on it by myself by any stretch of the imagination. And so in a lot of ways, I kind of looked as myself as the advocate for my friends and the son, kind of within the representation. So it was one of those things where I would oftentimes have to kind of partition, mentally what I wanted to do as a lawyer and then what I wanted to do as their friend. It was a rough time for them. And so I felt the calling at the time that, you often think of if someone's going through a hard time, like what is the way that you can help them? Is it by, giving them a meal? Is it by, helping them, cut the grass or something like that? And so here was something I had to offer. I felt like this is something I can do. This is something I can give to them.
How are they doing now?
They're doing well. I will say it's interesting. The young man who was 7 years old at the time is actually going off to college this fall, which is just unbelievable. I mean, this poor boy was resuscitated a dozen times. He spent 2 months in Johns Hopkins, and then 3 months in Kennedy Krieger, which is a rehabilitation facility inpatient. So there was the thought that he was not even going to live. And that was the expectation. And there was even the thought of, God forbid, was he better off if he didn't survive, just given how severe the injuries were and how bad the prognosis was.
You talk about how heavy it weighed then. Your sigh, which may not be picked up on the mic or on camera, still shows how heavy it is today.
Yeah.
Gray, can you talk a little bit about what happened, the crash?
Yeah, so it was something where it wasn't a slam dunk. So my friend was driving. He was bringing his son home from I think it was Taekwondo practice on a Saturday. Just kind of a normal Saturday. They'd gone to Taekwondo practice. They were going to stop at Costco and pick something up, and maybe stop at the food court at the Costco up in Maryland. And they're driving down the road. They get in the left turn lane. They're waiting at a stoplight, and there was a Ford F-350 with a commercial trailer. So this huge commercial vehicle with all the weighted down, and it was a utility trailer on the back. Just came crashing into them at 45, 50 miles an hour. The driver of the vehicle, he had diabetes, and he basically had went into like a diabetic coma. So, those familiar with the law are going to automatically think, okay, we've got a, medical emergency defense. And that's a defense in Maryland. And it was a situation where we were able, through witnesses, and just kind of reconstructing things, because the police wanted to call it a medical emergency. But we were able to track down witnesses who showed that this man had been basically driving erratically for about a minute or two before then, had gone off the road, had corrected, and kept driving down the road. He basically had all these opportunities to pull over and stop driving, but he kept driving. And one of the things that kind of just made me sick was that he had this diabetic coma, if you will. He, has the crash, and he then grabs a Snickers bar out of his pocket, takes a bite, and he's fine 30 seconds later. So it's just one of those things that just makes you sick, just how this person had just, it was easily preventable. And so it was a case, but for a period of months, the prosecution, we were holding back, waiting for the prosecution to handle the case. And it looked like it might not go well, that they wouldn't be able to get a conviction, or that they were going to buy into the medical emergency defense, but thankfully through just getting witnesses, and there were people who were good Samaritans who stepped up and were willing to tell what they saw, and that made all the difference.
So did you all assist with the criminal prosecution? Did you get
We assisted in the sense that we provided
evidence? Right. No. I get
Correct.
it. Yeah. Okay. Cool. I didn't realize that. Wow.
It's prosecutors like to keep civil attorneys at bay.
No, that's right. But actually for the work that we do,
Of course.
Especially, some of the cases that Gray lets me get into, or I get into, and we like to have the prosecution go first, right? Because there's so much more. They have so much more investigative authority and the ability to actually get stuff. So then when we can get involved, we can get their file in a sense and piggyback off of it.
So we started with Gray's calling. Zac, I'm going to go to your calling. So why don't you tell me the calling that led you to personal injury, and then especially here, Broughton Injury Law.
So I guess we can start from the beginning. I spent about 7 years on active duty in the Marine Corps, where I was primarily a prosecutor during my time. And in 2019, got out of the Marine Corps, moved back to Virginia because I had family here. That was the main sort of impetus there. And I was able to take a position with the city of Richmond. And that was my foray into civil litigation or civil practice. At the time, I had no experience in that form. I'd only done criminal practice up to that point. And I, was working in the capacity of a defense attorney, essentially for the city of Richmond, where we would defend civil litigation claims. I spent about 11 years in government service, mainly because I had hefty student loans at that point. So that was one path forward to kind of get those resolved. And it took about 11 years. And then through the public service loan forgiveness program, I was able to get those discharged. And that at that point, that was sort of the jumping off point for me to look outside of government work and to finally get into private practice, which I'd been anxiously waiting to do for a long period of time. And in many respects, it was just kind of fortuitous that the timing worked out. And I wanted to I wanted to stay in a civil litigation context or capacity, and personal injury was sort of the natural place to go once you've done civil litigation defense. And I think, there's certainly some parallels between a prosecutor mindset and a plaintiff's attorney. You are representing the aggrieved party, whether that's, the government or a victim of sexual assault. You got to have sort of a burden of proof mindset. You've got to have an investigative mindset. So, I always felt that, in fact, when I was doing the civil litigation defense, it to me kind of felt like I didn't have a background in this coming from the prosecution. So it felt sort of like there was a tension or a discomfort for me doing that. And honestly, having found plaintiff's work, it's much more cohesive with what I'd done in the military. And I always felt very passionate about my time as a prosecutor, enjoyed that work significantly, and feel much more at home as a plaintiff's attorney than I did really in the civil defense context. But just ended up being fortuitous. Gray was growing his firm at the time. I saw a job opening. We were able to connect, and he was gracious enough to bring me on, which he probably still regrets to this day. But
just the Marine part of
yeah,
it.
exactly. But it worked. It's worked out very well, and that was 2 years ago. So,
and the firm is still growing because the firm is going to be
Judge
moving.
Nael is going to come join us, right?
And there's a move in the next few months. So talking about criminal prosecutions, Sharif was also a criminal prosecutor.
Thanks for adding that part.
there was a long delay there.
There was a long pause.
And that's where I had the privilege and of meeting Sharif Gray. And it's probably one of the best things that I can take away from criminal prosecution. And I don't say that just in front of Sharif. Everyone knows that and my relationship with Sharif. So Sharif, I know your calling. I'm not sure everyone else knows your calling. What led you to personal injury? And you often tell me how prosecution is very similar to PI.
It's the same thing.
And you say, now you're giving value to a human life or a human injury. We're prosecuting, we're doing it. And so let's first talk about your calling, and let's also bring in that criminal prosecution, how the similarities.
Sure. So I found this type of work by accident, which is a word I actually don't really care for. And I'm sure Zac and Gray will tell you they probably see my motion a little bit too much. So I try and get rid of the word accident when we go to trial, because accident has a mens rea, right? And so, and actually, knock on wood, the Virginia Model Jury Instruction Committee should be meeting on that in October. So hopefully we get that changed. But I did criminal work for the first 6-7 years. I mean, I was an Army JAG, mainly did criminal defense work. I clerked for a couple judges, and I actually mainly did, at least for the federal district court judge, mainly did criminal work. I did McGuire Woods. I did white collar work, which is very different from traditional criminal work. And then I prosecuted with you, and then I realized, you know what, I want to go be a criminal defense attorney again, because I like kind of the David v. Goliath approach. But before I go do that, let me go see if I can learn what this thing called personal injury is, because that sounds a little bit like David Goliath too, with the insurance companies and all that. And so I got into it, and I mean, at first I didn't necessarily know what to think, like, oh, medical bills, people getting hurt. That's the name of the game, right? And then actually I met Ryan Walker, who you and I know well, and Ryan kind of opened my eyes to this different version of personal injury. And it's our job is more than just compensation. Our job is deterrence. It's to hold the wrongdoer accountable, be it an individual or a corporate entity, with the goal or the mindset of making a difference, of making the world a safer place. And I have learned that if you do that, and that's your approach, which is the same goal of a prosecutor, the money follows. The compensation that recognizes the value of one's health and what was taken from their quality of life, it comes with it. There's a saying that I heard at a conference a few years ago, that the purpose of a verdict is to deter, and damages, the money, is just the means to enforce that, right? And so when I realized, like, wow, I can prosecute, potentially affect change at corporate levels, right? And at the same time, instead of saying, hey, victim, the guy's not in jail, I can say, hey, here's at least the second best thing. Here is money to try and make up for what was taken from you. And so I've fallen in love with it. I really, really like the work. It's not a job for me, as I joke often, and it's not really a joke. My wife's on the couch watching like Love Island or some dumb thing on TV, and I'm on my computer watching trial videos. So I really, really, really like it.
I can vouch for that. So when I met Sharif, I was getting spammed throughout the day, including
wasn't spam,
including 1 and 2 a.m. in the morning with trial videos. And if you know Sharif, if he finds a training anywhere, he's going.
Oh, yeah.
Yeah, you know, whether it's Jerry Spence, whether we're going to Florida, whether we're going to Vegas or California, Sharif is there. And it's interesting you touched on the fact that a verdict is to deter, right? I was overseas not too long ago, and I was asked to go skydive. And then I was like, yeah, I'm all up for it. But then I started thinking about it. I was like, you know, people in this country are not really held accountable for their wrongs because the judicial system is not similar to our judicial system. So what incentivizes a skydiving company to make sure that everything is up to par? So if I jump, from a perfectly operable plane, that I'm going to actually land safely. And I was like, I'm not doing it. It's the accountability and being able to hold companies accountable, being able to hold people accountable that leads to a safer environment. And in a way, that's owed to personal injury attorneys. It's that verdict, that deterrence, making sure they're doing what's right. And if they do what's right, then guess what? The service that they provide is going to be a safer service for the consumer. So it's so that deterrence part is one of those things that I didn't think about until more recently when I thought about jumping out of a plane.
So did you jump?
No, we'll jump here together.
Okay. I'm not doing it, but no, I mean, it is prosecution. I genuinely believe that if you're doing this work the right way, it's prosecution. And I mean, I'm sure people will differ with me, but also it's a lot more fun. I mean, otherwise it's, hey, my client was hurt. Here are the medical bills, and have a good day.
One thing that I've noticed about this firm is that when negotiations are coming to a stall, you're not telling yourself, hey, I have to try this case. You're telling yourself, hey, I get to try this case for this victim. And that's one thing I appreciate, because instead of finding the difficulty in the trial work, you're actually looking at the opportunity of the journey to make this victim whole. So let's talk about that. Why Broughton Injury Law? How has Broughton Injury Law gotten the reputation of being trial attorneys?
Well, I think one thing is just not being afraid to go to trial. Very few cases go to trial. And I think over the years, fewer and fewer from a percentage wise go forward to trial. They end up settling at some point or another. And so I think if you go into a case, if you're filing suit, you should file suit with the expectation that you're going to try the case. If you're not willing to try the case, then you really shouldn't be filing suit. And so if you're taking that step to file suit and kind of throw your hat in the ring, you've got to be able to back it up. And so, most cases will still probably settle before you go to trial. But I think the thing that we've all learned in different ways is that, you should, especially your good cases, you shouldn't give them away. You should want to take those to trial. And obviously you have a client and you want to do what's right by your client, and your client, if there's a settlement offer that they want to take, ultimately, you've got to do right by your client. But you're absolutely right. It's an opportunity to try a case, especially if you have a good case. Because what's better than trying a good case? Everyone has tried the case that they don't want to try, that they were forced to try, and you look back and you're like, oh, I probably shouldn't have filed suit on that one. But yeah, if you're filing suit, it should be a case that you feel comfortable taking to trial.
Sharif, I know you love to try cases. How do you reel back that urge to always go to trial?
I'm not good at it. In terms of, I want to try cases. I even tend to think I have this. It's a double-edged sword, right? Like I think, oh, I can pull it off on this one, right? And and ignore maybe, or not give as much credence to maybe some of the bad facts. So I am not great when it comes to negotiations. I'm impatient. I would prefer to just put it in a courtroom and go. But at the same time, and really to Gray's credit, I mean, we've got an emphasis on, we've got however many cases, however many clients, and we want to get the best result for everybody. And so the cases that should be tried, certainly will do so. The cases that should be resolved, again, of course, as long as it's in accordance with the client's wishes and goals, we'll resolve them. And so I mean, it's something that I work on, but my tendency is that everything that we do, or not tendency, but my hope is that everything that we do is with the eye towards trial. And so when you take that approach, suddenly depositions become a lot more fun. And you can be a lot more creative. Same thing with discovery. Same thing with the creativity that you can get in your pleadings and your motions practice. So all of it matters with an eye towards what happens in that courtroom.
Zac, to you, how do you come to the value that you think a case deserves? So when there's that negotiation, you're like, hey, should we go to trial? Should we not go to trial? What is the aha moment for you?
So, one thing I would say too, in terms of, and it kind of ties into the question that you're asking, and I think all of us acknowledge that, developing a value for a case is not an ultra scientific or formulaic process. There is an art to it. In some respects, I wish it were as simple as what insurance companies do, which is they take the medical specials and they add a multiplier to it, and that's kind of how they arrive at the value of a case. But that does not comprehensively or speak to the holistic losses that our clients have experienced in their personal lives. And one of the things that, I've come to recognize over time with having an eye towards trial is you, by forcing yourself to kind of go through that process and to really prepare a case for trial, the secondary and tertiary benefit of that is that you are going to end up extracting the best value out of the case because you have to learn your case on a more intimate level than you otherwise would. If you're an attorney who says, look, I'm going to take this case, I'm going to get it wrapped up, as fast as I can. Maybe you're only taking a superficial approach to the case. And if you've got an eye towards trial and you are willing and ready to go to trial, you're going to have to take the steps to prepare for trial. It's not just a declaration. Okay, I'm going to take this case to trial. It means that you've got to do the work. You've got to talk to the witnesses. You've got to prep your directs and your crosses and your opens and your close. And you got to make sure you have an understanding of the medical damages. So by going through that process, you gain an intimacy with the case. And I think that's where you're going to be able to extract the most value out of it.
You touched on a point that I think about a lot, and you said you gain the intimacy of a case. How do you connect with a client where you're not just sympathizing for them, but you empathize? And it becomes more of a story, because an injury is an injury, but how does the injury affect everyday life? And if, for example, we're talking about your son's friend, we're talking about a value to someone losing their leg. And now it's 10 years later. The injury happened, they went through the pain, and 10 years later, they're still struggling with it. How do you get the jury to empathize with day-to-day life and how it's changed when you do lose a limb? How do you create that? How do you leave that impression with the jury? How do you try to their emotions?
Yeah, I think that's where the preparation for trial comes into play. And like something like that, you could have a doctor talk about the medical procedure, and you could talk about the stay in the hospital. But I think until you're connecting on a human level with the family, the mom, the dad, those who knew those who knew the boy or the person who's injured, those anecdotes, those bring the story to life. It's, the medical bills, everyone, especially in Virginia, we look at medical bills heavily, but it's really the stories that bring a case to life and give it value as a result. And kind of, when we're talking about trial, trial as a personal injury attorney, going to trial is really your only leverage. Insurance companies don't settle a claim and pay money out of the goodness of their heart. They're a business, and they're going to collect premiums and they're going to pay out claims. And it's like any business; they want to bring in more premiums than claims they pay out. So, if we weren't able to go to trial, insurance companies wouldn't pay out anything. And so, if you're not preparing a case for trial or thinking at least about how would this present at trial, then you're kind of wasting your time, because ultimately that's all that matters.
The story, Sharif. How do you try to emotions? And it's a question that, as a prosecutor, I used to ask myself before I put a case on. Often I would get up and was very dramatic. And the reason why you're dramatic is because you reel them in. Either I'm holding a gun and I'm holding the bullet that was removed from the brain of a 16-year-old girl. And I just hold them up for about 16 seconds because this young girl was inside of a shoe store for 16 seconds before this defendant took 16 years of life by that bullet. And I just pause, right? And some people say, well, no. It's for them to appreciate this is just not a simple trial where you're just putting on evidence and be like, no, this is someone's life. How do you tell the story? How do you try to emotions? Because we all know that's what moves us.
Sure. You know, it's interesting when you say try to emotions. In my head, I'm thinking manipulate, and I think that's, and I know that's not what you mean.
No,
but that's something that we must avoid, because trying to play to someone's emotions comes off as manipulation. You lose, it's not authentic, and you lose credibility, and that hurts your case. I think the way that you do it is through story and through guiding and being the guide that the jury trusts to hear and learn about that story. And the story comes from the friends, the family members, the coworkers, the witnesses, the good Samaritans, like in the case you had, Gray, who came out of the woodworks to testify. By being able to better help those people share those stories and talk to the jury, I think that's where you get the buy-in. Now, there's another thing that I think is at play, especially in our cases. I think with personal injury, as the plaintiff, similar to kind of like the criminal defendant in a criminal case, we walk in behind. We walk in with the stigma of you're just another one of those greedy personal injury lawyers. The settlement was probably fine, and you're just here because you want more, and you wouldn't settle this case. Granted, I certainly can't speak for everybody, every juror, right? But I expect that is something that certainly comes up. And I think our main job as personal injury trial lawyers at the beginning of the trial is you can't explicitly shift it, but it's to shift it to show that we're here not because of us, we're here because of them. And there are ways to do that. But I think if you can do that and you can gain the credibility and the trust of the jury, and you can tell the story in a way that the jury can relate, like the little things. It's not, as Joe Fried said when we had him on, right? It's not the broken foot. It's the feeling that person can't feel anymore when they want to rev the engine of their favorite car, or the lady who likes to wear high heels when they go out on the weekends and they just can't. It's that feeling. That's the value. And to be able to tell the story in a way where people can relate to that and understand the importance of that, I think that's the way you do it. And then also, I mean, give juries something to change, or something that they can fix, right? When you give somebody a job or a responsibility and empower them to make a difference and let them know that their verdict can actually do so, I think that's when you start seeing the larger verdicts.
Sharif, you talk about empowering jury. Often, your defense attorneys get up and say, well, this is the law. You have to follow the law. And you kind of take that power away from them, and you tell them, this is what you got to do. But you started with, they get to make the victim whole. So you empower them by telling them, hey, you get to make the victim whole and do right with the victim's story. And in a way, now they're an active participant in making the victim, as whole as they can without that limb.
Well, there's a Jerry Spence line that he uses at the end. Well, and I mean, maybe he came up with it, or who knows. But at the end of his case in rebuttal, he'll go up to them and say, "This case is no longer mine; it's yours. You get to write the end of the story about what happens."
Never shared that with them.
Well,
it's probably one of the videos that I think you
right.
sent at 2 a.m. But that's what it is. It's empowering them to get to take part of the story, get to make this victim whole. So now we're talking about trial work, and we're talking about jurors. I'm going to go around, and I want to see, what part of the trial do you enjoy the most? And I'm going to start with you, Gray. And why?
I probably enjoy voir dire the most. Jury selection, just being able to connect with the jury from the get-go. I mean, they're going to learn about the case during voir dire, and that's your only opportunity to make a first impression. And so I think it's oftentimes overlooked. And here in Virginia, jury selection goes by very quickly, especially when you're looking at states like California, where it takes days and things like that. Here in Virginia, for a civil trial, where we have jury selection, and then you're into opening statements in probably a couple witnesses at least before lunchtime. So you don't have a lot of time, and so you've got to make it count.
Those judges are not very given. Okay. I can say that's me saying that.
Especially those Henrico judges. You're one of them now, right?
I sure am. I'm blessed to be one of them. So voir dire. A lot of attorneys dread voir dire. Why is that?
I think you have to make yourself vulnerable. You're up there. You're connecting with the jury. You're not necessarily talking. You're talking a little bit about the case, but you're not getting into the evidence. But so much you're asking. You're examining the jury. So that can be a little bit awkward, especially if you're getting into something where a jury member, it might be something that they don't want to talk about, or something that they've tried to forget, and so you have to be careful.
And Gray, not a lot of attorneys like to come across as vulnerable, but you're exactly right. Showing that vulnerability leads to that connection. And we're dealing with humans, other humans. And I often say every single human in this world is 99.9% genetically identical. So the person that you're talking to is 99.9% genetically identical to you. They're not a different creature, but in our mind, they are. And we build it up. And it's something that we see often. Zac, I'm going to you now. What is your favorite part of trial?
So this is held consistent through prosecution work in the Marine Corps, and then particularly, even today on the personal injury side. And it has to do with carrying the burden. And I love doing rebuttals because of that. To me, I love that we get to have the last word. I mean, it also means that we've got to carry the burden ultimately, right? And we had to carry the burden, whether you're a prosecutor or a plaintiff's attorney, but we get the last word. And I recognize, there's only so much you can do to sway opinions at that point, right? The jury has received all the evidence. They've been sitting there listening to you for sometimes multiple days. Their minds are very likely made up, right? But there's still an opportunity there. And to me, I love being able to get up and correct misrepresentations. And particularly, I remember, as a prosecutor, I would be so frustrated listening to the way that the defense spun the facts. I'm sure Sharif would have been a nightmare to deal with on the defense side.
Would never spin.
Right, exactly. And I would just be stewing at just ready to get up there, chomping at the bit to get up and rebuttal and to try to correct the record and to correct the misrepresentations and try to be somebody who is viewed as, the most credible person in the room. So for me, it's always been rebuttal. I love that portion of the trial.
I appreciate the burden, and I've always, told myself, hey, because you have the burden, you want to kind of own it. Some prosecutors don't want to mention that they have the burden. Do you remind the jury that the burden is on you?
We do, and I always did as a prosecutor, but I tried to put it in the proper context. I think on the prosecutor side, it was talking about it doesn't have to be beyond all doubt or any doubt, and reframing that and explaining what reasonable doubt is. It's not all doubt. It's not any doubt. And I don't like to run away from the burden. And I think, in a civil context, I personally view preponderance of the evidence, even though it's our burden, as a huge advantage. I mean, when you're used to working within a beyond a reasonable doubt context, preponderance of the evidence seems like a fairly low bar to get over. So personally, it's not something that I shy away from.
Do you think jurors appreciate what it means to be beyond a reasonable doubt? And that's one of the questions I always ask myself. I'm like, arguing beyond reasonable doubt and arguing preponderance of the evidence or clear and convincing, some judges don't appreciate it. You think some of the juries appreciate that? And if not, how is it more of a who do they believe? What moves them?
I think you're right. I mean, I think it does come down to credibility. I don't think the jurors think about it in a theoretical context in the way that we hold up a ruler and try to measure these things out. I do think it often comes down to credibility, and the jurors don't have probably an exacting approach to beyond a reasonable doubt in the same way that an attorney would, or even preponderance of the evidence. So I do think it really comes down to who they believe the most.
Yeah. Sharif, I don't know if I even want to ask you this question about what's your favorite part of the trial.
Yeah, I think
He's
you
going to
know what
start.
it is. Yeah, you know what it is.
So let's talk about your favorite part of the trial.
I like voir dire in opening statement. And I mean, voir dire for the reasons Gray mentioned. And I think there's a lot we can do in voir dire that isn't done typically that can be helpful to our case. And then opening statement, I view opening statement very much as one of the most important parts of the case because you get to, you lay out the entire case. Like I remember in law school, you kind of do the roadmap for closing argument. And then in closing argument, you go through everything. Now I've learned it's the opposite. I mean, opening statement's it. So those are my favorites. But I've come to enjoy it all at this point. So like it.
You know, you and I have talked about this a lot. I believe in Virginia, the opening is one of the most powerful parts of the trial. You dictate the lens that the jury sees the whole trial through. And when you start telling your story, and if you start getting the jury to nod, and Sharif, you and I have talked about that, and they start to agree with you, what gets invested? Their ego, right? There's video on that. Their ego gets invested. Now they're part of your story. Each nod is them nodding with you and agreeing with what you're telling them. And it's going to be a lot harder for the other side to get them to turn against now what they believe is true because they've nodded with you. And it's that lens. You put that lens, and you know when I want them to give me a stronger nod, I kind of get a little closer, right? And
You nod with them.
Yeah, I nod with them, and they start to nod with me, and then you go with it. So yeah, but the voir dire is powerful because there are some jurors, even though we don't say it's not about removing jurors, it's about selecting jurors. There are some jurors you don't want on your jury.
Oh,
Right?
absolutely. And if you don't talk to them, then you won't know that. I mean, and especially if you're just looking at someone's, age, where they live, and what their occupation is, or if they're retired, that doesn't really tell you anything. You could have someone who on paper seems, very conservative and kind of defense friendly, but you learn a little bit about them, and they might end up being your biggest advocate in the jury room.
One of the things that I'm starting to appreciate more, jurors, just like judges, they like to be led. Humans love to be led. I mean, a simple purchase on Amazon, you go and you click, you search it, you find the one that's highly reviewed. You don't know a single person that reviewed that particular item. But blind loyalty to what they think is the item. And you're like, look, buy. And now it's at your house. Restaurants. What is the best restaurant near me? So now, touched on it briefly, it's one of those things that you sit on a bench and you're like, well, counselor, how do I get there? Lead me. And it's one of those things that jurors also are asking themselves, how do I get to the verdict? How do I get to the value? How do you take me there? A lot of young attorneys miss that notion. And we talk about simplicity. Life is simple. We complicate it. Keep it simple. So keep it simple.
Yeah, same thing with our cases, right? I mean, a lot of our cases aren't that difficult, right? I mean, someone did something wrong, and because they did something wrong and they knew about it and they shouldn't have done it, and someone got hurt, right? I mean, that's not to say that our cases are that simple, but oftentimes I think we overcomplicate things.
How do you simplify an expert witness? Especially y'all deal with a lot of medical bills. How do y'all simplify that?
Medical bills or medical experts?
I'm sorry,
just
medical
in general?
experts. And you have medical bills, you need an expert to justify these bills and so forth and so on. How do you simplify that to a jury?
We were actually at a training not long ago, Mark Lanier's Trial Academy, and he used a lot of really kind of cool analogies and just different visual examples to help take what would otherwise be like a complex joint or something like that, and to use, I don't know, we'll say water bottle, whatever it was, to kind of to simplify it. My approach, and I learned this actually from Joe Freed, is every witness, to include your expert witnesses, the question that every question should be answering is why are they here? Why should they listen to them? Why is this important? So expert witness, first question, sir, what's your role in this case? Great. Thank you. Are you able to help us understand this? Yes. Are you able to help us understand that? Yes. Why are you the right person to tell us about all these things? Great. All right. Let's talk about thing number one. Can you share with us how you got to your opinion as to that? What did you consider? Why does that matter? Why is it important? All that. And so by being able to like organize, I think, your examinations in a very simple and concise manner and make it very clear what you're trying to have the expert or any witness share with the jury, I think that's how you simplify it. Once you start getting into like all the legalese and the complicated medical stuff and diving in all the different medical certifications and all that stuff, I think it can be somewhat lost.
You know, you touched on something that kind of brought me back to how I ask questions. Why are you in this case? Often you see attorneys start with the first question, what is your name? Introduce yourself. I used to start with, and I did until there's an objection, and your son was killed on July 4th of 2023. Before we get into that, why don't you introduce yourself to the jury? And why is that? Because the jury doesn't know who this person is. You put that piece of the puzzle right up front. So now they're thinking about, this lady lost her son. And you said it. You start with, hey, why are you a part of this case?
Yeah, why do you matter? And then I think a lot of that also comes back, I think I'm quoting Joe Freed a lot, but the whole speed trial notion of it's not get faster, it's cut what you don't need. I mean, we don't need 100 witnesses. You don't need an hour-long before and after witness testimony. You need a couple good stories, that quality over quantity in almost every phase of the trial. And I mean, Ben Rand and I, we did that trial in Henrico in a day a couple years ago, and we got a hell of a result. And we went through like 12 witnesses. And I think we as lawyers tend to just really also in pretrial stuff with discovery and deposing everybody for hours and hours. I mean, it's oftentimes we overdo it.
We talk about simplicity. I mean, that's one of those things. You try a murder case, they want to bring in 20-some witnesses. I've tried a murder case with 6 witnesses. We got stipulations on witnesses that don't matter, and first-degree verdict in 20 minutes. And it's simplifying. We talk about it because the jury doesn't have that experience. So part of the audience that Sharif has built up for this podcast, looks forward to advice from someone who started a big law and was doing very well. But then when you felt like, hey, it's an injury to a person that you love was a calling to take you into a different direction, you actually saw that as an opportunity and you took it. What do you tell those listeners about, getting out and just following your passion?
Yeah, I think you can't look at it as a job, and it's certainly not something you'd want to do as like an easy vocation. And Sharif probably lives this more than anyone I know, but like you have to have a passion for it. If you don't have a passion for what you're doing, life's too short. Do something else. It's not something you should, back into. You should go, full speed ahead into it. And and also one thing that I'll always try to think about is, I like to live by the golden rule, which is, treating others as I would want to be treated. And so if you kind of look at things like that, whether it's dealing with a client, even dealing with opposing counsel, if you kind of sometimes step back and just look at things that way, it can make things a lot easier. But yeah, that's basically it.
Zac, I'll go to you and I'll go to Sharif after that. What is some advice you give younger attorneys, they're trying to find their way, you know, and because a lot of young men or young women go to law school saying, hey, I want to be an attorney, but they don't know what to do. And then they stumble upon a internship, or you may have an attorney that's been practicing for 3, 4, 5 years, and they just hate what they're doing. How do you find your passion?
Well, I know this is, as I understand it, sort of a trial lawyer's podcast and geared towards those listeners. And I'm probably not the best person to give advice outside of, that field. I've never done transactional work and the like. So, if I was talking to somebody who, is in law school and they're considering litigation or trial work, and they, they want to they're thinking about a good path forward for that. What I would encourage them to do is to seek out positions that are going to put you in court as often as possible. Get into, if you're willing to go the military judge advocate route, I think that provides wonderful opportunities to get great litigation experience and trial work early on in your career. If that's not something that you're interested in, I would consider you to look at district attorney positions or public defenders or the like, jobs that are going to get you into trial. Be somebody who is willing to seek out things that make you uncomfortable. Get outside your comfort zone. Run towards the resistance in some respect, because that's what's going to sharpen you. That's what's going to make you stronger as an attorney. If you are waiting until you feel like you're ready to do it, you're never going to have that level of comfort. So in some respects, you just got to leap. You got to get out there. You got to get in the courtroom, stand up, make the arguments, go to the motion hearings, ask to get, second seat in the trials, seek out as much litigation experience as you can and as early as you can in your career, because it will serve you well for the rest of your career as a foundation that you can stand on and grow from.
Sharif.
Yeah, I agree with all that. I mean, there's so many resources out there, but probably the biggest thing is don't be afraid to reach out and help and ask for help, or ask for advice, or to go to that conference, right? Or to apply for that scholarship. That's how I got into PI. That's how developed a lot of the connections that I have. I remember finding this conference called Trial Lawyers University, and I was getting my LLM at the time, so technically I was a law student, and there was a scholarship for law students to go to cover the ticket. And I applied, and through that, I met Sean Claggett, and Sean Claggett has become a friend, and he's actually helped us with a case. And I went, and that opened a lot of doors. And so by just being willing to kind of put yourself out there to ask for help, 9 times out of 10, people are going to respond in a kind and positive way. But so anyways, and then also, of course, I mean, I'm partial, but because all of us were former JAGs, 2 Army, 1 Marine, unfortunately. But
never misses an opportunity.
No, I never do. I never do. That's my biggest
Zach
line.
is jealous. Yeah. That's all there is to it, because he's not a Marine. That's as simple as that.
I can still get the tattoo.
Blatantly so.
But no, I mean, I'm a big believer that if you want to get into trial work, or really kind of anything, I mean, JAG is the way to go. It's a good paycheck, get to wear the uniform, serve your country, get great experience. No one's ever going to fault you. And if they do fault you, then you probably don't want to work with them for having spent time in the military. So I think that's, as a young lawyer, there's nothing better than joining the JAG Corps. I'm partial, of course, to the Army, but...
And I'll bring in, look, serving is powerful, right? Serving there's nothing more powerful than serving your country. You can serve your community, and that's as a prosecutor. You can serve the Constitution and the less affluent and those that didn't have the resources and the blessings that we had growing up, and that's defense attorney. So you can serve in many ways. And I've said this before, in order to be a good trial attorney, and a good trial attorney that's recognized as a good trial attorney, you got to be a good human being. And there's a reason why. You're trying to other humans, and you have to connect to those other humans. And if you're not a good human, people are going to see right through you. And we talked about earlier, Sharif, you touched on the fact, it's not trying emotions. I was focusing on the empathy. How do you get them to empathize with the injury, with, what their struggles? And if you're not genuine, and if you can't connect to the jury, they're going to see right through you. So, and I'm not, I often say the best attorneys are the greatest humans. Those are the best trial attorneys, and we've seen it. I see it in this room right here, and I've seen it, in our podcast. And one of the great examples is Craig Cooley and how when he tries criminal cases and how he carries himself. And that's one of those things you got to keep in mind. You just got to be a good human being, regardless of what you do in life. You agree with that notion?
I think so. Yeah. So, well, now this has been fun. Thanks for having us.
Well, Sharif,
you're the host today, man. Your honor.
Hey, this is your arena. Hey, we're all playing in it. Gray, Zac, Sharif, it's a pleasure. And I appreciate what you all do. And I'll tell you, it is tempting. It is tempting to step off that bench every time I walk into this office and I hear of a great verdict, or I talk to Sharif and he tells me how amazing the work that you do is. So keep at it. Wish you all nothing but the best. And I hope you all continue to grow. And there's a move coming up August 1st. And hopefully the next time I see you tell me now, we're going to a bigger office. And y'all deserve it.
Absolutely.
I wish you all nothing but the best. Thank y'all.
Thank you.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.